Welcome to another episode of our legal podcast, brought to you by Siam Center Law Group. I'm Barrister Garn, and today we will discuss the 5 types of court appointments in criminal cases here in Thailand. If you find yourself facing criminal charges, it's important to understand the various court appointments you will have to attend. Let's dive into the details. The first appointment is the ready date or the court testimony date. During this appointment, the court will inquire whether you plan to contest the case or plead guilty, and if you have legal representation. It is mandatory for all defendants to attend this appointment as per Section 172 of the Criminal Procedure Code. Failure to appear may result in an arrest warrant issued by the court. The second appointment is for reconciliation or the protection of the defendant's rights. In certain criminal cases where the offense is not against the state, there is an opportunity for the defendant to reach an agreement with the victims. If both parties can come to a resolution, the case may be concluded. However, if the offense is against the state or a compromise cannot be reached, this appointment serves to protect the defendant's rights and may assist in subsequent court proceedings. The third appointment is the evidence examination date. During this session, the judge will discuss the evidence guidelines with both the prosecution and the defense. This includes determining which witnesses will be called and what specific issues they will testify on. If there are any documentary or material evidence that needs to be presented, the court should be requested to issue a summons prior to the evidence examination date. The fourth appointment is the witness examination day, which is a crucial stage in most criminal cases. Both the prosecution and the defendant will present their evidence to the court. Typically, the prosecution presents their case first, followed by the defense. The outcome of the case heavily relies on the testimonies provided during this appointment. Lastly, the fifth appointment is the judgment hearing, where the defendant must personally appear in court. This appointment is of utmost importance as it determines the final decision in the case. If the defendant is convicted, they may need to submit a petition to the court to continue their bail. The court may require an increased bail amount, considering the higher risk of flight after a conviction by the court of first instance. It is crucial to note that, except for specific exceptions provided by law, the defendant is obligated to attend all court appointments in a criminal case. This requirement ensures that defendants are fully informed about the process before any dismissal or punishment is determined. That concludes our discussion on the 5 types of court appointments in criminal cases in Thailand. If you require legal assistance or have further inquiries, do not hesitate to reach out to Siam Center Law Group, where our team of experienced lawyers, including myself, Barrister Garn, is ready to provide guidance. Thank you for listening to our podcast. Stay informed and empowered. Until next time.